And this boat accident, guys, was really important because it really uncovered the financial problems in the family, which really led to the demise of, really, Alex Murdaugh. All right, joining me again as my guest, folks, criminal defense attorney Jack Rice and David Bruno. And Jack, I'll start with you. You heard Joe McCullough talk a little bit about it. He represented Connor Cook, someone involved in that crash. How is this going to play into the trial? How important is it, do you think? We heard today testimony that the first thing, literally the first thing out of Alex Murdaugh's mouth was referring to maybe some of the fallout from this boat crash might have been the reason why his wife and son were laying dead on the ground. Your thoughts on that?
Well, I think it's interesting, Michael, because I think you alluded to it. It kind of cuts both directions, doesn't it? If we think about what it is that the state is suggesting, they're suggesting something inappropriate, like he's setting this up as some sort of an alibi. On the other hand, from a defense perspective, you can make the argument that the prosecution actually introduced what this is actually about. And they may actually be able to turn that around and use it. Because while the defense doesn't have to prove who did this, a jury naturally wants to know that it was somebody, and who would it be? It's very useful to be able to turn that around, hand that to the jury and say, it wasn't us, but you know what? We have a pretty darn good idea who it is. And you know who introduced that? It was the state. Yeah. That's one of the things that they're thinking about right now.
Yeah, I would agree with you 100%. And David Bruno, in a case where I feel the Achilles heel of the state's case is the motive, that someone would commit these brutal murders to cover up financial crimes, not just brutal murders, but brutal murders of their wife and son. When you have a situation like this where there is the possibility of some other explanation, I think it takes even more importance.
Yeah, absolutely. We saw a little clip there of the defense attorneys making the argument why the probative evidence is substantially outweighed by the prejudice. And that is, under 403, the rule of evidence that most states have, is that we want to be trying defendants based on the evidence of the particular crime, not of bad act evidence or prior act evidence to show that he has a propensity for committing crimes or that he's a bad individual. And I'll tell you what, I believe it is a stretch. It is a stretch just because they had these disclosures coming up and the boat case coming up. And just because he says that there may be people that wanted to kill him, I don't believe they're going to be able to get that out. And if it does come out in front of this jury, I believe that it is an excellent issue for appeal should he be convicted. That is essentially putting this bad act, bad person evidence in front of this jury when this case is about a murder. Whether or not he killed his wife and his child should not be relevant to whether or not he had poor financials on his law firm, in my opinion.
Jack, I got to get your opinion on this because it is a tenuous connection. They're slipping it in against this bad character evidence normally wouldn't come in. The state is sort of slipping it in through this motive situation. And so is that just clever lawyering, or is it really what they think happened here?
See, that's always our problem, Michael. I mean, in the end, this is what will happen. You'll have all sorts of exceptions to the issue. I mean, the idea is to say this isn't about him being a bad guy and bad guys do bad things. There's exceptions to this when it goes to motive, when it goes to all sorts of other reasons. But you know what? I don't think juries actually can make the distinction. I think frequently when juries hear this, what they think is bad guys do bad things. And if bad guys do bad things, and you can show how bad this guy is, he could have done this thing too. And that's the problem. Is it inappropriate? Of course it is. Is it good lawyering? Well, you know what? The nature of every trial I've ever had, from murders to simple assault cases, is that you're always fighting two things. You're fighting the question of who did it, what happened, but you're also fighting that fight beforehand, which is what information can you get in front of those people? Mm-hmm. And in this case, those prosecutors are trying to roll in a piece to say, this is a really, really bad guy. Don't you forget it.
Yeah, and how much of that comes in, we still don't know. Judge Clifton Newman has reserved that ruling on that motion until we come to that point in the trial. So we shall see. All right, stand by, gentlemen. When we come back, a mother stands.